All right, U.S. government, this is lecture number 3. We've had one on the basics of how the court system, and in particular the Supreme Court, works. And remember, you'd want to send me notes, hand-taken, or e-done on that basis. The second one was a look at a couple of the very early major Supreme Court cases, and then how the 14th Amendment brought that into brought the Bill of Rights into the states. And you will notice that I've left you with this little form I have for taking notes, a little bit of spot so that you understand what the 14th Amendment does. So you'd want to put in some accurate information there. And then basically the major court cases along the way. I think it's a 4-page document. You'll notice that I've got the major cases. There are a few that I will mention that do not make it here. And that's just fine. That's fine. It just means you're not responsible for them. But you see there are about 30 or so cases that I think are worth knowing about. And the issue at stake, what was the issue about, maybe who are the major players. Many of these cases, there's a particular part of the Constitution. So maybe that should say relevant amendment or part of the Constitution. Is it the necessary and proper clause, the elastic clause? Is it the commerce clause? Is it a First Amendment case? Is it, the 14th Amendment was used to enforce this? Was it a Fifth Amendment, a Sixth Amendment case, etc.? And then outcome, impact, etc. Why is it important? What was the long last, what happened? Who won the case and why? What was the long-term impact? Basically, you want to capture as much as you can so that you'd be able to look back at this before the end of the year and say, okay, on these 3 or 4 pages, I got a pretty good sense about what these cases are. Remember, there'll be a theater-ish project that's going to be related to this later, but we'll get to that. Today is pretty quick. What I'd like to do is look at all the cases up through the famous Brown versus the Board of Education case in 1954. So it's actually going to be pretty much just that first page. I've got a longer middle one and then a shorter last one coming your way. So far, we have already talked about, of course, Scott v. Sanford leading into the Civil War. Civil War leads to the 14th Amendment, and we'll go from there. Plessy v. Ferguson, another absolutely hugely important case. I would argue that it has tremendous relevance today. On one hand, it has since been overturned by a later case. On the other hand, some of the ways that the United States developed fundamentally because of the outcome of this case, and I think we're still working to get past it. Notice the year is 1896, and so this is about 30 years after the Civil War ended. You all might remember from U.S. history last year that after the Civil War was a period called Reconstruction. Now, reconstructing wasn't really just physically rebuilding the South, where most of the fighting happened. It was also rebuilding it socially. And look, now that we have African Americans who are no longer slaves, and most African Americans, I've got to say, 90+% lived in the old states of the Confederacy. I mean, nearly all, or 90+%, had been slaves. So they can't be slaves anymore. They're guaranteed equal rights of citizenship, at least the men are, and they have the right to vote. Well, wouldn't be surprising then that if African Americans are now voting and receiving some degree of equal treatment, they are in fact electing people that are standing up for black people. You do see in the 1860s, 1870s, you see African American senators and congresspeople and governors and local police chiefs, and you do see some major changes. You might recall we were talking about the presidents earlier in the past unit. You might recall that we had talked about how a lot of northern whites frankly got a little bit tired of, the expense and the difficulty of providing for equal rights. And of course, white southerners, they wanted their society and, hate to say it this way, but their control over their coloreds back. You might remember the key election of 1876. That was that election that was basically a tie, and it all came down to whether the Democrats or Republicans won Florida. Well, the backroom deal was made. The Democrats, you'll recall, said, hey, look, we'll let you Republicans, we'll let you guys have the presidency, but you got to do something for us. Pull federal soldiers out of the South. Let us, white Southerners, we'll handle our race situation. And that agreement is made by the Republicans who, frankly, were probably as racist or unconcerned about the average life of the average African American as the white Democrats were. So There you go. Well, in 1896, a man named Homer Plessy, about one-eighth African American. I've seen photographs of him. I suppose he would look black. On the other hand, he could have easily passed without, and passed off as a white person. His great great grandfather would have been African American. Well, Louisiana law had said, this is a post Reconstruction law, whites and coloreds ride in separate train cars. Well, Homer Plessy, you might know the name Emma Park, not Emma Parks, Rosa Parks. I don't know where Emma came from. Rosa Parks. Well, this is 50, 60 years before Rosa Parks. Homer Plessy, as an activist, got onto one of the white train cars, and nobody noticed because he wasn't dark skinned, and said, "Mr. Conductor, I'm a Negro and I'm sitting here. Boy, you need to get off of this train right now and go to the colored section. Sir, I'm not doing this. 14th Amendment, equal treatment, equal protection." So he sues. He's found guilty. He takes it to an appeals court, found guilty, makes its way to the U.S. Supreme Court. Homer Plessy is the litigant. Litigant means the person bringing the suit. That name always comes first, by the way. Plessy v. Ferguson. Plessy is the person bringing the case. My guess is that Ferguson was probably either the chief of police or maybe a law enforcement official from Louisiana. I'm not certain, but it would have been the state of Louisiana. Here's the issue. Is the Equal Protection Clause of the 14th Amendment violated by Louisiana's law? And I think we would say, well, wait a minute. You're saying that if you are darker skinned or your great great grandmother was African American, therefore you can't ride in this train? Well, of course that violates the Equal Protection Clause. However, this is 1896. And that's not what the decision ruled. Only 8 voting members at this point. I believe somebody was absent or had died recently. It was a 7-1 ruling that separate but equal facilities are acceptable. By the way, the one hero in this, a justice named John Marshall Harlan, that is not the John Marshall who would have died 70 years ago, the first Supreme Court justice, but a later one named John Marshall Harlan said, "I'm sorry, this is wrong." He wrote that dissenting opinion saying, "We made the wrong decision. Justice, if we're going to have real justice, it's got to be colorblind. We can't treat people differently because of their color." Why is this important? Because honestly, for close to the next 60 years, this was the precedent setter. And virtually every time somebody said, "Hey, I'm darker skinned. My grandmother was African American. Both of my parents are African American. I should be able to go to this school." The courts would say, "No, I'm sorry. In Plessy v. Ferguson, the precedent was set. Separate is okay as long as the facilities were equal." By the way, if it's Ruskatu, Alabama, with a white mayor, white chief of police, white school board, white city council, whites with the guns, whites with the economic power, how equal do you think the facilities were? And of course, the answer is they were never equal. But because the U.S. government had said, "We're staying out of this, you white Southerners, make sure you treat the black people equally," they had the ability to institute a system that, honestly, by the early 1900s, you could make an argument it was worse than slavery. Now, it was not legal ownership. And there's something awfully important about that. Even theoretically, being a citizen and a full human being is pretty meaningful. But the amount of violence, the amount of discrimination, the poverty, the lack of opportunity, the humiliation, the United States racially is a very, very, very ugly place in the early 1900s. And frankly, it ain't too great today when it comes to those things. And it's certainly gotten worse in the last couple of years. But major, major case. And the key thing about this, I know I'm spending a lot of time on this one. They won't all be this long. This was how the U.S. government looked at matters about racial equality for the next 60 years. Kind of interesting, you might recall that a couple of the so-called progressive presidents, Theodore Roosevelt, this is during his time period, by the way, Woodrow Wilson later. The idea that maybe government should do something to make people's lives better. And it's not just certain presidents or US senators, it's also states. Well, the state of New York said, hey, we should limit working hours. We have people that are working 70, 80, 90 hours a week, and that's not fair to them. So the New York State of New York passed a law that limited working hours to 60 hours a week. And yes, that's a lot of hours. The litigant is the bakery owner, Joseph Lochner. He sues the state of New York. The state of New York rules against him. The appeals courts in New York rule against him, and he has his case heard by the Supreme Court. Here's the question. Did the state of New York have this power to limit the number of hours? Did it violate the due process laws of the Fifth and 14th Amendment? Or could you make an argument that this is a necessary and proper law? Could you argue, perhaps, and certainly the lawyers do argue this, that because some of the bakery goods are being bought from over state lines, that through the Commerce Clause, perhaps this is allowed? Well, in this particular case, the ruling was, and notice it's 5-4, it's awfully close. This law is not valid. Why the court ruled, and I'm sure there were very harshly worded dissenting opinions, this exercise of state of New York power violated the freedom of contract. In effect, if I want to hire you and tell you to work 90 hours a week, and you're willing to work 90 hours a week, that takes precedent over any law that the state of New York might pass. Obviously, different laws today, but that's an early on case. This is a real interesting one. Shank versus the United States, 1919. If you're paying a little attention, if you enjoy U.S. history or just even world history, 1918, what ended? The answer, of course, is World War I, and the United States got involved in World War I starting in 1917. Well, there was a socialist named Charles Shank, and during the war, he printed up and used the U.S. mails to send out 15,000 mailings, flyers they're called, telling young men, don't join the military. For many socialists, the argument was, look, this is not a war for working people. This is rich people in every country, the arms makers, the people that own property, and they're sending young men, mainly poor young men, out into these horrible trenches to die. Eugene V. Debs, my grandfather's hero, in fact, he ran for president 3 or 4 times as a socialist. Eugene Debs, in fact, spent, I think it was 7 years in prison because during the war, Eugene Debs had said, you know what? You're accusing me of opposing this war? I do oppose it. I hate this war. I couldn't care less if you are born under a German flag, an American flag, a French flag. Doesn't matter to me. This war is wealthy people sending young boys out to play with guns. You better believe I will do everything I can to stop people. Charles Shank had the same approach. There was a law called the Sedition Act that was passed during the war. Sedition means treason. The argument was if you're standing in the way of the U.S. winning the war, well, obviously you're committing treason, you have committed a crime under that Sedition Act. You might ask yourself, under what constitutional amendment is Charles Shank going to argue he had the right to do what he was doing? And of course, this is the First Amendment. You have the right to free speech. You have the right to free assembly, to free press, in other words, to print what you want to print. He was not lying or making things up. He was presenting his arguments as to why this is a terrible, terrible war and people shouldn't fight. Of course, the government would have argued, oh no, these are dangerous words. They could weaken our war effort, cost us to lose. You might ask yourself, if you're sitting on this court case, do you believe Charles Shank has a right to openly oppose the war while the United States is in it? Well, the court ruled unanimously that a free speech conviction in this case, the conviction was constitutional. One of the main judges, named was Oliver Wendell Holmes, he wrote, free speech does not protect a man in falsely shouting fire in a theater. In other words, we acknowledge there are limits to free speech. There are. You can't scream a threat, cause deaths, and say, ha ha, I was kidding. I don't know. I don't personally don't think it applies that well to this because this was not shouting fire. This does not mean I'm trying to create trouble. This is I'm acting on my political beliefs. Um, my own belief is that Charles Shank would have been a hero for doing what he did, and the court should not have found him guilty. The Constitution, again, is a piece of paper. In my opinion, and there are those who would disagree with me, the Supreme Court failed to uphold the Constitution. But Charles Shank went back to prison as well. A similar case a couple of years later. In the 1920s, there was a major Red Scare in the United States. There was a fear that communists, that anarchists, that radicals were coming and taking over the country. Well, Benjamin Getlow was a young man who had published what he called the Left Wing Manifesto. Basically, it was a this is what we need to do to get rid of this corrupt capitalist government that we have, etc. New York State had passed a criminal anarchy law in 1902 to stop people from making statements against the state. Well, he was found guilty, sent to prison, exhausted his appeals, and brought it before the Supreme Court in 1925. Again, First Amendment, right? I'm not saying that you agree with Getlow's left-wing manifesto. I'm not saying that he's right. But do you have the right to say what you believe, to write what you believe, or only to say what the government wants you to say? Now, remember, 6 years earlier, Charles Shank had been found guilty and his First Amendment rights were not upheld. What happened with Benjamin Getlow? 7-2. You'll notice a couple of justices said, wait a minute, I'm not comfortable with this. I think the New York State law is wrong. But the argument here that was made of the majority is that the state needs to control speech that might advocate for the overthrow of the government. And the key phrase from this is, look, these words had a clear and present danger. It's not just that we don't like these words. It's not just they make us uncomfortable. It's not that we think they're unpleasant or anything like that. We believe it provides a legitimate danger to the government. Again, probably if I heard the whole case, I would find myself being on the side of the dissenters in this case, but nonetheless, this is the case. I think I got two more for you. What is going on in 1944? And the name Korematsu, what ethnicity is that name? Well, you perhaps know that as of December 8th, 1941, the United States was at war with Japan. The United States had some 100,000 Japanese Americans. Now, some of these were immigrants from Japan. The larger number, I think about two-thirds, were people of Japanese descent who were born in the United States and therefore, by definition, U.S. citizens. There began to be some concern. If the United States is at war with Japan, is it possible that these Japanese immigrants or Japanese American citizens might be disloyal to the United States? Maybe we need to round them up, put them somewhere so they can't damage U.S. war effort. Franklin D. Roosevelt, who is actually one of possibly my very favorite president in American history. I'm not real thrilled with this. He gave into pressure and issued an executive order. Remember, an executive order is the president telling the government to enforce a law. It's Executive Order 9066. And as a result, about 100,000 Japanese citizens, Japanese Americans, American citizens whose parents happened to have been born in Japan, were sent to internment camps for about a year and a half, 2 years. These are camps out in the western part of the United States. Now, these certainly are not these are not Hitler's extermination camps. However, they're not nice places. Disease was a problem. Poor food quality was a problem. The death rate was a lot higher than it was on the outside. And especially long-term devastating is that most of these Japanese people and Japanese Americans living in California, they in effect had to leave their property behind. And a lot of it was taken and simply never given back. An interesting sidelight to this, there were actually two parts of the United States with a heavy Japanese population. One was California, and these Japanese people and Japanese Americans were sent to the camps. The other was in Hawaii, which was not a state then. But in Hawaii, the Japanese and Japanese Americans are largely laborers. They're needed in the agricultural fields. The economy of Hawaii would have fallen apart. These people, despite the fact that Pearl Harbor, where the attack came, was in Japan, they were left alone. The Japanese Americans in California tended to be wealthier, tended to be property owners, and somebody gained hugely by getting those business owners out. So it may not have been simply a matter of racism, and it may not have been simply genuine concerns about national security. There may also have been a who's going to win here if we follow this policy economically. By the way, there were absolutely no German or Italian Americans sent to any type of camp at all whatsoever. It was exclusively the Japanese Americans. Fred Korematsu, again, born in the United States, English speaking, as an American citizen. What does he argue? 14th Amendment rights. Because of my parents' race, I am going to be locked up and denied my freedom? Would seem to me that there's a pretty ironclad case. And there isn't. The Supreme Court rules 6-3. It's not a unanimous decision, but it's a clear decision that the circumstances of war said that this can happen. I don't think you will find too many people in the United States today that say that this was the right decision. It's definitely an embarrassment. Now, people do say, again, it was not Hitler's concentration camps. There were legitimate fears about a war really for the soul of the world. The decision was wrong, but we can understand how that decision was made. And others just point out that, you know what, it's a thing about race. It really is. We saw the different complexion, eye shape, the language, and decided, well, the Germans are kind of like us with a bad ruler, whereas these people are inherently more dangerous. By the way, the United States in the 1990s formally apologized. As a government said, look, we were absolutely wrong. We apologize. We are going to make restitution to those who are surviving and to their descendants and try to give them some of the money and property back. But we made a mistake. We've got to do better. Interesting, here we are in 2019 and specifically banning people from certain countries, particularly Muslim majority countries. We have also had cases of U.S. citizens, people, and exclusively, as I far know, Latino people, people that were born in the United States and the 14th Amendment makes them citizens who are being denied renewing their passports. Think about this. And the last one for today is one many of you are familiar with. This is Brown versus the Topeka, Kansas Board of Education. Interestingly, Brown is actually not Linda Brown. It's her father, Oliver, because he was old enough to file a lawsuit. And it's the Topeka, Kansas Board of Education. In our federalist system in the United States, nearly every city or county has its own separate school system. There's a little bit of money that comes from the national government, but they're fairly independent. Well, Linda Brown was a 7-year-old African-American girl who would get up in the morning and walk for about 20 minutes and go past, you know what, a nice school. It was new, it had new equipment. I don't know if it would have had air conditioning at that point, but it had electricity, running water, textbooks, reasonable number of students in every classroom. Linda Brown would look at it and keep walking. And she would get on a bus that would take her about a half an hour away. She would get off the bus and walk further. And she'd go down to this beaten down old school, probably had a leaking roof, maybe didn't have electricity in all room. Textbook for each student? Of course not. Of course not. They made do with what they could get, the hand-me-downs from real schools. Rather than having, let's say, 22 students in a room, well, there might have been 30 or 40, and they weren't necessarily the same grade level. I don't know specifically about Linda Brown's school, but it wasn't uncommon to have first grade through, well, whenever you stop going to school, all in a single room with a few books, etc. Now, why was she not allowed to go to the school close to her? Well, because she was black. She was African American. That was the rule of the Topeka, Kansas Board of Education. And when people challenged this, they said, oh, well, separating by color is fine. Plessy v. Ferguson. We just have equal facilities. Now, anybody paying any attention would see these facilities aren't equal. Of course, the problem is nobody outside of the white power structure in Topeka, Kansas was paying any attention. Well, Oliver Brown, on behalf of his daughter, says, you know what? 14th Amendment, hey, court, revisit, revisit Plessy v. Ferguson. We've been pretending in this country for 58 years that, oh, it's fine, we'll just make all the facilities equal and everything will be fine. And I think it's really, really, really clear that's not the case. Some things had changed. There were a few other cases in the 1920s, 30s, early 40s where people were starting to question this and small changes were made and some African Americans were allowed, for example, into a law school in Texas, et cetera, et cetera. Also, I think you can't possibly overestimate the importance of World War II. Hey, after all, why did we go to war against Hitler and the Nazis? Oh, they were terrible, they were racist, they were evil, they were... Oh. Ooh. Hmm. And you would find people that had just without even thinking about it, they had accepted the segregation, they had accepted the racism. Maybe a small number of whites start saying, hey, I think we might be wrong here too. And you've certainly got African Americans who play a huge role in World War II. Wait a minute. I just went overseas and fought for democracy and fought for equality and justice and decent. You know what? I'm going to continue the fight back here at home. So this is a major, major case. Happy to say, and this is where the name Earl Warren comes in. Earl Warren from California. He was the Chief Justice of the Supreme Court. He's the guy that basically changes what the court does. And actually, in the next video lecture, we're mainly looking at the Warren Court years. Earl Warren says, you know what? This has got to change. However, however, he is afraid because the court is divided that if there was a 6-3 or 5-4 decision, that doesn't really send a very clear message. In other words, the segregationists, those who want to keep black and white separate, could say, well, we lost this case 5-4, but don't worry, we win the next presidency, we'll get a Supreme Court that will agree with us. And Warren works really hard. He talks repeatedly with the people that are going to disagree, with the justices who say, no, 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 Topeka, Kansas law is fine, and is able, through being political, through being convincing, I think, for really just reminding people, what was at stake here. He's able to get all 9 members of the Supreme Court to sign off on a decision that makes this unequal. And it makes this unconstitutional. And here's the key line. Separate is inherently unequal. The moment you look at somebody and say, because of your race, because of your sex, because of your wealth, because of your religion, you're not welcome here, you know what? You've created inequality. Let's not pretend, oh, don't worry, it'll be fine. It's not going to be fine. Now, here's the problem, and this is where Warren had to try to get people to support him. Some were concerned. If this means starting tomorrow, the doors are open and black Americans join white schools, the concern was, and this might have been legitimate, there could be bloodshed, there could be violence. So the Supreme Court look at this language. Hey, Topeka, Kansas, and other schools, you're violating the 14th Amendment. Schools need to desegregate. And look at the wording here. With all deliberate speed. If I start talking deliberately with you, that means slowly. Oh, but speed is fast. What are they saying? We're going to order schools to desegregate with all slowness and speed. What does that mean exactly? Well, it's a way of assuring white Southerners we're not opening up your school doors starting now. It's got to happen, but we can take our time. You might recall there was a famous case in Little Rock, Arkansas, 3 years later, where the U.S. 80th Airborne soldiers came in with guns to make sure that black children had a right to go to Central High School. On the other hand, I had a real interesting conversation with a friend in Austin, Texas named John James. John James is doing community organizing stuff. Little old, about a decade older than I was. And John James said, well, I was from Southwest Louisiana, and it was my senior year we desegregated. But John, how old are you? He says, I graduated in 1971. I said, John, 1971, naively I said. Brown versus the Topeka Board of Education was 1954. You wouldn't have desegregated in 1971. He said, Robert, I lived in Southwest Louisiana. And he just kind of smiled at me, and that's where I realized I didn't get it. There were some major moves toward desegregation, but the reality is, and you can look up the statistics on it, the United States of today, our school districts are far more segregated than they were 40 or 50 years ago. One of the things that I feel like I got the luckiest with, I went to a high school that had about a 40-45% Jewish population, had an African American population, 40-45%. We actually had a Chaldean, a Christian Arab population. We were sort of your ultimate melting pot school that had people from every imaginable background, and actually even economically, we had some very wealthy kids, and we had some very poor kids, and a lot of middle class kids. The United States has abandoned that almost entirely today. We don't say, "Oh, you're black, you're Latin, you're Latino, you can't go to this school." It tends to be more subtle than that. It's economically, if you live in a poorer part of town that might be almost entirely black, well, you go to the black school. And there are also ways of making people feel less welcome, I suppose, as can happen as well. Nonetheless, major case 1954. This is the birth of the civil rights movement. 2 years later, Rosa Parks refuses to get off the bus. Martin Luther King becomes a international spokesperson for racial equality. You've got a decade after that, Lyndon Johnson's laws, the Civil Rights Act of 64, 65. That 15-year period, the country changes racially dramatically. And for most of us, it really started in 1954. Okay, it's about a half an hour in this. We'll do a few more tomorrow with the next video, and then one more after that. And there we go. Again, you're not sending in notes for this, but you are keeping track on that little form that I sent you and keeping track of the major info that you're getting from this, and I'll have you send it to me at the end. Y'all have a good night.